Today on Law Weekly, we look closely at the legislation changing the name of the Nigerian Prison Service into the Nigerian Correctional Service. We talk to the Attorney General and Commissioner for Justice in Ekiti State, Mr. Olawale Fapohunda. Mr. Fapohunda has drafted and played key roles in the advocacy of several justice sector reform bills and is arguably one of Nigeria's leading experts in justice sector reform. Also showing on the program, the Lagos State government restates its commitment to keeping Lagos safe. Its DNA and Forensic Center says it has worked on about 300 cases by applying a scientific approach to investigations and prosecutions. Plus a recap of the top trending stories from the courtrooms. Hello and welcome to the program. I am Shola Shoyeli. On Wednesday, the 14th of August, President Muhammadu Buhari assented to the bill changing the name of the Nigerian Prison Service into the Nigerian Correctional Service. The Correctional Service Act 2019 repeals the Prisons Act and is geared at ensuring a transformation in the management and administration of prisons in the country. To look closely at the provisions of the Act and what it seeks to achieve, I spoke to the Attorney General and Commissioner of Justice in Ekiti State, Mr. Olawale Fapohunda, who was also the chairperson Interministerial Committee on the review of the Prison Act. The committee drafted the bill. I began my interview by asking Mr. Fapohunda how he feels now that the bill has finally become law.
The first time that this process started was in 1999, and since 1999 we have spoken to each successive government till now on the need to do something about the prison act as it then was. Well, thankfully now we are there. I think it can only be positive. Yes, to take more than just enactment of law to achieve the kind of reforms we desire. But I think it's always helpful. Having an appropriate legal framework is undoubtedly an important step towards prison reform. So our concern all these years was, if we are spending so much on prisons, if we all agree that, we have to do something radical about the prisons, why are we then struggling with the law? Why do we have to keep resorting to a law that was last reviewed many decades ago? But anyway, fast forward, where the law, Mr. President has enacted the law, the National Correctional Services Act. That is very useful for us. The name, a lot of people have asked me what is in the name. For years we have said, there is a need for a reorientation with regards how we look at prison and how we deal with prisoners. Many of us have said that, the moment once a person is convicted and is serving the sentence, then we should not impose additional burden on such person. There should be opportunities for reform. So, correctional services simply focuses on that. It looks at the whole prison structure again, and there's a change in philosophy now that let us now focus on correctional services, on correcting inmates instead of punitive, punishing inmates. So it's positive.
Beyond the name of the bill, what are the other laudable objectives?
One of the positive things about this act is that it recognizes the importance of the role of the head of prisons in terms of setting an agenda for prison reform. The other area which we have said over the years, which we have raised concern about, is with respect to prison congestion. We've said severally that we cannot continue to be loading, if you will, prisons with persons, even when we know that the prisons is full. So thankfully, this act now empowers the state controller, as it were, to reject inmates once a particular prison is full. Now, a lot of people have again raised concern about that. If you reject them, where do they go to? But it's a process. There's a protocol involved. It's not simply bringing prisoners to a prison and the controller says, no, we don't want. There's a process. So the moment, the act gives a time frame for the controller to start flagging that particular prison. So once he knows that the prison is about to be filled to capacity, he will begin to engage the chief judge of a state, possibly even the attorney of the state, the criminal justice regime on the state, to begin to raise those issues that, the prison is full, what can we do about it? The other area which I found very useful is also the prison visitor system, prison visitors regime. For many years we have said that, the monitoring prisons cannot be left exclusively to the prisons and prison officers alone. There is a need for independent persons to go to the prisons and, talk to inmates, talk to prison officers, and have an appreciation of how that particular prison is being managed, or the welfare of both inmates and prison officers alike. So what we now have it's a framework where you have eminent prison visitors who would go to prison, and the important thing now, unlike before, while they just go to prisons and the findings, nobody knows where the findings go. Now there's a framework where they can actually report to the prisons or even to the relevant bodies about what is happening.
But how do we ensure that the prison itself benefits from the Act? What must major stakeholders do?
Well, the Act by itself will not solve all our prison problems. We have said so severally. There is still the whole issue of administrative justice reform, which is crucial. The prison is just one component of a whole institutions that are required to achieve efficiency in prison administration. So, you have the Administration of Criminal Justice Act at the federal level and law in some states. Obviously, there has to be an interface, Another issue that we have raised, another important issue that we keep raising that is very important to achieving prison reform is the police. Just like the prisons, the last time the Police Act was reviewed was many, many years ago. We have said again severally that we cannot hope for effective policing that will eventually lead to arrest of offenders if, we don't have an appropriate legal framework for the police. So I hope that going forward, both the National Assembly and the Presidency will look again at what many, many people have said. There have been multiple committees on the need to look at the Police Act again and, enact, a legislation that makes sense, not to the police, but also helps our criminal justice system. Judiciary is crucial again in that. We've talked about judicial reform for forever, When we talk about judiciary, emphasis is always, placed on Supreme Court, Court of Appeal, High Court. But many of those who are in prisons actually today are there because of, decisions of magistrate courts. We need, and across the country, across the 36 states of the Federation, lower court judges are suffering, whether I call them magistrates or area court judges. Their conditions of service are nothing to write home about. So it's important again, while we look at a holistic reform of our prisons, while we look at a complete review of our criminal justice system, not to forget the magistrates. Certainly, we need to improve the conditions of service of magistrates.
Let me take you back to something you said about the role of the prison head in setting an agenda. What, in your view, should be the prison agenda?
To start with, if a Controller General of Prisons must have a vision, a long-term, short-term, medium-term, and long-term vision for the prison, that is crucial. I am not quite happy with the qualifications that was included in the Act, with respect to the kind of qualifications that the Controller General of Prisons should have. In my view, we need, someone of the highest level of qualification in criminology or what have you, any related, field. But, with respect to the role of the Controller General of Prisons, I think it's important that, lies with every other institution. The head of institution must set an agenda for the prisons. And across two main areas, conditions of prisoners, that is crucial, How do we ensure that, working in collaboration with other institutions, prisoners don't stay in prison forever, 10 years, 15 years awaiting trial? How do we ensure? Thankfully, the present leadership of the prisons. They've tried to find solutions to that in terms of procuring additional vehicles, ensuring that a large number of prisoners, unlike before, have access to the courts when they are called to come to the court. So that is useful. But the other area which I would think that the Controller General of Prisons will focus on is the conditions of prison officers themselves. Because preach from January to December about the plight of inmates. If the prison officers themselves are not happy with their own conditions of service,
nothing will change.
We are not going to make any headway. So for me, it's important that in addressing the concern of the state of prisoners, quality of services they have, where they are staying, we should also look at the conditions of service of prison officers, because ultimately they are the ones who eventually will implement whatever measures, whether it's this law or whether it's any administrative intervention that we want to make the prison change.
You also talked about the police force and a police reform system that must make sense. What must we put into the police reform system that would make sense, and who should drive the process?
We keep talking about insecurity in this country, but the question I ask, is, given our level of endowment of Nigerian police today, can we honestly look at ourselves and say that, given what we have put into the police, we can expect a police force or a police service that responds to our concerns? So, the whole discussion about police reform has to look, and the tragedy is that every government, including this one, there's been a committee, there's been a high-level committee, there's been whatever have you, to look into the state of the police, and they all come with the same conclusion. If you do not invest in the police, you are not likely to get the best out of the police. But somehow, the message is still not there. We expect a lot from the police. We expect the police to deliver. But there's no shortcut. We need to recognize the police as an important institution in maintaining our security and put money where it needs to be.
The new act talks about custodial service and non-custodial service. What's that get at?
One of the complaints we have that has been quite frequent about the state of prison and how we deal with those who offend is that we seem to have this hardline sanction attitude. So whether it's minor or serious offense, the first point of call always appears to be prison. And we are saying that there is everybody. We don't have to put all offenders in prison. We need to get to that point where we recognize that there should be alternatives to prison. Minor offenders do not necessarily have to go to prison. We need to find a way in which we can deal with those minor offenders. And thankfully, one of the implementing mechanisms that the Act has provided is this committee, to look at, the practical steps in making that happen.
So if all these major stakeholders collaborate and do their part, we'll see a reduction in the problem of awaiting trial inmates, which is an issue that's been plaguing our prison system.
The bill will not immediately decongest our prisons. As I said, it has to be, as you said, it has to be every body, every institution, every organ of the criminal justice system doing its own bit. The judiciary needs to do their own bit. The police also need to do their bit. We need to recognize within the police the important role of the police in getting people to prison. So I hope getting the legal framework around the police will probably help. You also need awareness. You need training for the police. The prisons will have to also do their own bit. So, defense lawyers will also have to do their own bit. So across board, I think it's only when we all collaborate that we can achieve prison decongestion. But again, it's important to stress that this act is not the solution to prison congestion. It's an important solution to prison, but it's not the single solution to prison congestion.